we'll set a limit of 2 Latin phrases.
Just 2? No.
I'm not sure we're agreeing to that.
Okay.
Good afternoon, Your Honor. May it please the court, David Slade for the state of Nevada. I only come up here just to engage with Your Honor's question about whether or not any of the relief that the state seeks would curtail third-party content being on the platform. Is that right? That was the question that Your Honor had?
It was kind of a little broader, is it wouldn't require prospective, right? Because counsel said that it's not requiring anything actually to be done with any content. You know, nothing would need to be deleted, so the court's question was focusing on future. Doesn't the relief require future things with regards to content or not?
Your Honor, our position is that it would not edit or prevent Facebook, or excuse me, Messenger, or any of the Meta properties for that matter, but in this instance, Messenger, from removing, editing, making any type of editorial decision about what third-party content could or could not be shown on the platform. We're going strictly after design features, which are entirely agnostic to the content. So this could be, these could be recipes being shared for, sheep pan dinners. They could be animal videos. They could be terrorist recruitment videos. It really doesn't matter. None of the features that we seek to have remedied or addressed on Facebook or on Meta and properties in general, and in Messenger in particular, that harm children, none of them, even if they are changed or altered in the way that the state would wish, would prevent Messenger or Meta from showing any type of content that it wishes. It is just the manner in which it would be shown that is addictive and harmful to children.
So how would that go with scrolling?
Well, that's an excellent question. So with scrolling right now, it occurs in a limitless, infinite way, right? The scroll continues ad infinitum. But at no point in the complaint and at no point in the arguments that you've heard today has anybody talked about specific third-party content that is shown on the scrolling. We're not here to say that, oh my goodness, scrolling is bad because it puts people in contact with content that, say, espouses cyberbullying or makes people feel bad about themselves. It is the fact that it is an intermittent variable reward that harnesses a psychological impulse on the part of children that keeps them on there. Precisely.
Yes, Skinner.
Absolutely, Your Honor. So again, if we go to content itself.
Nothing negative on slot machines, by the way.
Right, no.
That's a known fact. There's been enough published studies, go to.
From your mouth to God's ears, we are not disparaging the gambling
No,
industry.
I'm not in any way doing it. I'm just saying. There's published studies on the nature of what you're saying in different contexts, which is going to lead to my next question once I let you finish your sentence. Go ahead.
Thank you, Your Honor. But no, I think that is an excellent analogy. And again, we're talking about the substance of what a third party wishes to say, right? None of that will be affected.
But what I've heard from Meta,
Mm-hmm.
right, is it would be, because if you're talking about scrolling, because that's kind of the easy example here, right? If you're asking to stop scrolling or minimize scrolling, then isn't the repetition of speech something that's being asked to be limited in some regards?
So Meta's argument is actually trying to split a hair here, right?
Okay.
The Section 230 principally encompasses third-party content. So, if you go to the New York Times and somebody says something wildly defamatory in the comment section of an article,
Right.
the New York Times cannot then have that defamatory content imputed to them in a subsequent litigation, right? And it exclusively goes to the substance of what this third party is saying and the New York Times' ability to avoid liability for it. Now, my colleague has seized on an additional verb in Section 230, which is publishing. And their argument is that it is not simply third-party content, but it is how the content is published that is something within the ambit of 230. And I would respectfully disagree. I think that is a huge overread, and it's inconsistent with cases like Snap, or Lemon v. Snap, cases like the Omegle case, the various orders that have been coming out in the states in these social media litigations, in this, the District of Columbia, Tennessee, Vermont, Utah. In those instances, what the courts have found is if we are talking about a design feature that is on the platform, like the Snapchat filter, right, in Lemon v. Snap, that determines how fast people are going, that induce these young children to drive over 100 miles an hour and get into a fatal car crash, that is entirely insulated from Section 230 immunity, notwithstanding the fact that it is a feature on the platform that they used to put content out there, but it was first party. It was something that Snap itself designed. And
Pizza delivery cases.
what's that?
Sorry, go back,
Oh, yeah.
historically, the radio cases.
Sure, absolutely. Similarly, the Omegle case, I'm not sure if I believe it came up in our briefing, where the gravamen of the claim was that it was irresponsible of the platform to match a tween with a 39-year-old, and that was the gravamen of their complaint, not necessarily the messages or the inappropriate contact that the 39-year-old had with the tween that resulted in her abuse. Instead, it was just that initial inciting incident that, it could have been any 39-year-old, it could have been any tween. That was the function of it. So again, this is about what the platform does, and it has nothing to do with what anybody says on the platform. So when you ask about the infinite scroll and you ask about the prospective changes, I would submit that has to do with how the platform itself is designed. It has to do with how it presents information. But our submission to you, Your Honor, and consistent with the cases that we've cited, is that has nothing to do with content. Content is the expression of a very specific idea, and it could be any idea. If we were here trying to say, Your Honor, we want Meta to stop allowing cyberbullying on its platform, and we have all of this data that shows that there are, 5 in 10 posts on Meta involve cyberbullying, and that's harmful to children. Section 230 would foreclose that. It would say you cannot tell Meta to censor specific types of content on its platform. But that's not what we're asking. We're asking simply to have guardrails put on how information is presented. But what information is presented is totally outside of the scope of this case.
Do those guardrails include the amount of information, the timing of the information? I'm going both to the notices question and
Sure.
the scrolling kind of in this court, in my question.
They do, Your Honor. And again, this is also, if I may jump a little bit, this is why the Moody opinion that the Supreme Court issued this summer is so important. Because in this landscape where the Supreme Court has clarified that decisions like what you just described and these efforts and on the part of platforms like Meta to figure out how information is arranged and presented to its account holders. This is first-party speech under the First Amendment, and it gets certain protections, right? And then if you extrapolate that, as the Third Circuit did when it reversed the district court in the Anderson case, said, well, listen, you can't say on the one hand that your decisions for how you present this information are yours and yours alone, and therefore entitled to your personal First Amendment protections. And then out of the other side of your mouth, say that Section 230 entirely immunizes you because, it's all third-party content. It's either first-party content or it's a first-party decision, a first-party, rendering of a decision in math. It either is, and therefore you get First Amendment protections, or it is, but you also don't get Section 230 protections, or it is not, and therefore what are we even talking about the First Amendment for?
Appreciate that was my question.
Sure. One final point I wanted to make is that independently of any of the Section 230 or First Amendment analysis, well, at least Section 230, none of that should touch count 1 of our complaint, which exclusively relates to affirmative representations or intentional omissions on the part of Meta in this context. It has nothing to do with any content on its platform, any publishing on its platform, it has to do with entirely first-party speech that Meta has engaged in about whether or not its platform is safe. So I would submit that count one is just entirely outside of the scope of section 230, and I wanted to make or perhaps belabor that point.
Okay.
Thank you, Your Honor.
Appreciate it. Thank you so much. Okay, State, you had your full opportunity, correct?
Yes, Your Honor.
Okay, back to Meta, go ahead, and yes, you get some extra time because the state got extra time, so.
Thank you, Your Honor. I have a few points I want to walk through, and then I suspect my colleagues will also have some points to make on the sections they argued. Let me go back to this point on arising out of or related to. I think the court has still not heard an answer from the state as to why these claims arise out of the contacts that Messenger has with Nevada. Even if we accept all of the contacts that the state alleges with the state of Nevada, the claims of allegedly addictive features or the claims of misrepresentation about the safety of Messenger, those claims don't arise out of or relate to the contacts in Nevada. Tri-Carici makes this clear. The contacts in the state must, quote, give rise to the claims. The Trump case says the contacts in the state, the conduct targeting the forum must give rise to the claims. They are not meeting that standard. Now, I want to go back in particular to the Ford Motor case, which counsel talked about. Ford Motor actually illustrates exactly our point. In Ford Motor, purposeful availment was conceded. The only question was whether the claims arose out of or related to the contacts with the state. The Supreme Court engaged in a very detailed analysis, and it ultimately found that the claims related to the contacts in the state because, quote, Ford had systematically served a market in Montana and Minnesota for the very vehicles that the plaintiffs alleged malfunctioned and injured them in those states. So it was very much focused on what the contacts were in the state that allegedly gave rise to the claim. Here, the state still hasn't answered that point. The contacts that they listed out, advertising, user terms of service, the research with Nevada teens, the preload agreements with mobile carriers, attendance at the trade show, those do not give rise to these claims of addictive features, and they don't give rise to the claims of misrepresentations. Now, the state ultimately came to this broad proposition, said, well, Met is an advertising business. Well, that is not the legal standard, and that would be legal error to find that the claims relate to or arise out of contacts in Nevada because Met is an advertising business. Ford was a car company, but the Supreme Court didn't say because there was an accident with a Ford car that established the arising out of or related to test. It was much more specifically tied to the specific contacts that Ford had with the state, with Montana in that case. And here, there has to be some specific showing by the state that the claims arise out of or relate to the contacts in the state, and it doesn't make the showing. And it would be legal error to say, well, because they're in the advertising business, therefore the claims relate to the activities here. If that were the test, any business anywhere in this country would be subject to personal jurisdiction everywhere. They're all engaged in business activity, but that's not the way the standard is applied. It has to be much more specific, and I think Tri-Carici makes that very clear. Second point on personal jurisdiction. The state said there was no law supporting the point that there has to be targeting or some specific activity focused on the state. Well, Tri-Carici says there has to be conduct that's specifically directed at the forum state. And there's any number of cases, and we've cited a bunch of them in our briefs, including the AMA case out of the Ninth Circuit. Conduct has to be expressly aimed at the forum. The ex-mission case out of the 10th Circuit, there requires a particular focus by the defendant on the forum state. the Admar case out of the Fifth Circuit, there has to be something that specifically targets the form state. And Admar court said, merely running a website that's accessible in all 50 states, but that does not specifically target the form state, is not enough to establish personal jurisdiction. And I think the one that's really quite helpful on this is the Dozier v. Twitter case we've cited in our briefs. The court said, quote, Twitter has operated a website and advertising platform that's accessible nationwide with no specific targeting of Arkansas residents. So targeting is a requirement. And the fact that Nevada is one of the 50 states, almost by definition, can't meet the test that's required, which is something specific that goes beyond the activity that they're engaged in nationally.
Okay, can I just pause you for a second? Okay, let's go to Ford, right? Ford didn't just sell those particular trucks in those 2 states. They sold trucks, right, throughout the US. The same model, same make, same year. They advertised throughout the country. I don't know about Alaska, but okay, at least most, or at least 40 some odd other states, right? So what I appear to be hearing you say that if, and I said something similar in March, is that if you do business throughout the US, that means you wouldn't have personal jurisdiction in a state such as Nevada. It appears what you're arguing. Are you arguing that? Because, I mean, Ford focused on, I mean, except those trucks, but it didn't say, and these trucks were only sold in these 2 states, right? The trucks were sold throughout the country. They used the fact that those particular trucks were sold in those states. And here, I don't hear that you're arguing on behalf of Messenger that the platform, app, service, whichever language you all are using, okay, i.e. Messenger, is not available in the state of Nevada. It clearly is, because they told me about the millions, right? And that was the whole jurisdictional discovery. There's very thick appendices with a lot of examples. So can you kind of clarify where you're
Sure.
going with that?
Sure. So let me break that down.
Sure.
First of all, in Ford Motor, purposeful availment was conceded. Ford conceded that.
Okay.
So we have that's different analytically from where we are here.
Okay.
And Ford also specifically distinguished the sale of physical products from internet services. It dropped a footnote saying it wasn't deciding how the doctrine it was enunciating would necessarily apply in the internet context, for good reason. Because one of the things that Ford highlighted was, what the Supreme Court highlighted in Ford was, hey, if Ford doesn't like it, they don't have to do business in Montana. That's a very different question than what confronts a social media service that's available everywhere where the internet is available. But the key point I wanted to flag is, first of all, purposeful availment was conceded. Second, and very importantly, the court did not find jurisdiction based on arising out of or related to, based on nationwide activity. It didn't look at the fact that Ford was advertising those specific vehicles nationally. It looked at what they were doing in that state. And they said that because Ford was advertising those exact models in the state and had a dealership network that was promoting those models in the state, that the claims of injury from those vehicle models arose out of the context in the state. But it was, the point is, it was very specifically directed, the analysis in Ford Motor was very specifically directed at what was going on in that state and whether it was fair to say that the claims, quote, related to that activity. I think here we have a very different situation. We don't have any contacts, any activity in the state of Nevada that even the state realistically is arguing give rise to these claims. These claims are based on activity that occurred elsewhere, and they're really unrelated.
Okay. Walking this through, right? Messenger is an app, right, that you can get, it should download from your local not being my best choice of words in the digital arena, but okay. Your preferred device, you can download it on, right?
Yes,
Regardless of whatever platform it runs off of, a Google-based, an Apple-based, et cetera, correct?
Yes, Your Honor.
So are you contending that the app was not downloaded in the state of Nevada and not available to the various people here in the state of Nevada?
No, it was available, Your Honor, and I want to make sure we keep this distinction between arising out of and relating to versus purposeful availment. I think the court's question now is going more toward the question of purposeful availment.
I'm segueing into the other one because, right, if they can download the app here in the state of Nevada, right, that does go to the purposeful availment, but then, right, then you have to go to the next step to the potential nexus. Does the harm that they're contending, right, is related to or arising out of the downloading of the app, the advertising of the information, the virtual reality headsets, all the different things that the state contends, and they have a whole long list, right, those other pages, of other things, right, that they're saying the harm to the miners with the end-to-end encryption or the other factors that they've related to, right, is because Messenger has allowed Nevadans, and it's personally availed itself to Nevada, right, and made this product, whether you want to call it a product, you want to call it a platform, you want to call it a service, you want to call it a transaction, they're doing their sub 15, okay? Different ones, you all are contending different aspects. But that then gets you to the harm that they're contending, right, arises out of the ability to have this app on your preferred device, whatever that might be. So that's where the court was going. I fully appreciate
Yeah.
the two separate analyses, right? And
I understand, that helps me understand the court's question. I think it would be legal error, actually, to base
doesn't everyone say that? I mean, honestly, in every single hearing, I mean, one side or the other, right?
Right, well, I mean,
The Supreme Court and the Court of Appeals gets to decide if I make legal error. I appreciate it, right? Go ahead.
to base the analysis on where the harm occurs is not correct. The analysis has to be whether the claims arise out of Meta's contacts with the state. Meta's contacts with the state are different from the decisions of the users who decide to engage with the service. So I think it's not the harm is not the basis for these claims. The basis for these claims are twofold. One, allegedly addictive features, and two, alleged misrepresentation. Those are the two claims. Now, harm could occur all over the country, but that's not the way to analyze it. We would submit that's not the proper way to analyze the personal jurisdiction question. The claims have to arise out of the contacts in the state. And the way that Ford analyzed it, for instance, it wasn't that people were harmed. That was known. People had been harmed in Montana. They'd been injured in a car crash or whatever in Montana. But that wasn't the way the court analyzed the question of personal jurisdiction. It was based on what had Ford done in the state that related to the claims of a defective product, not where did the harm occur. And there's a number of cases, I think Walden v. Fiore and others, that recognize that the location of the harm is not a basis for personal jurisdiction.
Maybe it wasn't as clear. The injuries could not have occurred with the trucks in Ford if the trucks were not available for sale. That seems to be a given point, right? You can't buy it, you can't get injured by it, right?
Sure.
Okay, and buy not being the key word in my analysis, it's having it available to you. You know, maybe somebody else bought it and gave it to you, the truck, okay, so it's not the buying aspect. But, so isn't the state contending, they're putting their lens on it, is that the app being available in the state is similar to those models of trucks being available in the state. And then that app being available to the state has the consequence of having the ability, then it is arising out of or relating to having that app in the state and still downloading the app to make my analysis more correct, right? And then actually using it, because some people may have downloaded and never used it, right? But that downloading and using the app is causing the harm as they contend, the addictive features, et cetera. So that's where the court was going. The court's not trying to reanalyze something that's different than Supreme Court precedent, I mean, at all. I'm just, so your contention, right, and the reason why I mentioned the other states is because in Ford, they didn't basically say, guess what, we sell it all over the country. And so therefore, we're immune because you can buy trucks anywhere, okay? Right, they focus on the fact the trucks were available in those two states, the injuries, and they, without going to the proximate cause analysis on the negligence claim, I'm really kind of focusing back on the personal jurisdiction, right? The arising and relating to. Having a bit of trouble trying to understand your argument on all of their examples. I'm not saying that they're correct or not correct yet, but all of their examples don't at least apply to the concept of arising from or relating to. Is that your contention, that none of their examples would equal that standard, or is just not enough to get to that standard, or that's what it's a little unclear to this court?
So our contention is, and maybe I can step back for a half step. In Ford Motor, the relating to test was satisfied because the allegation was a defective car
Mhm.
that was the exact same model that Ford had been advertising in that state and was promoting to other people in that state. That was the nature of the relating to standard. And they focused very specifically on the fact that those two specific models that had injured people were used there. Here, it's a different nature of a claim. The nature of the claim is based on design features. It's not based on the download by users of this app. Now, ultimately, the court is certainly right. Ultimately, there's no basis to allege harm unless a user was exposed to the app. That makes sense. But it's one step, at least maybe more steps removed from the contacts in the state, because the contacts in the state, first of all, are not, the harm here only arises from design features designed elsewhere. There's no allegation, for instance,
But
that
weren't
the
the design,
features.
okay, I'm pausing for a second, because Ford wasn't manufacturing as in the Ford case, right? They said they're not manufacturing in Minnesota, right?
Right.
As one of the two states, make it easy. Okay. So it wasn't where the physical truck, the vehicles were not physically manufactured in the States, that wasn't the issue. And so here, it's not the creation of the app. No one's contending that happened. Well, I don't know if you have remote people that work here in Nevada, but anyway, it's not an issue before this court, so I'm to address it. But so it's not that issue, it's not the manufacture issue, because, so app creation would be parallel to manufacture, right? So then walk through what you're saying, why none of the examples, and like I said, two-pronged arguments. I understand your second argument is, even if some of those things did occur, they don't have enough to equal it, okay? That 1 + 1 doesn't equal 2. And they're saying 1 + 1 equals 2, and I'm not saying 1 + 1 is not a good example. They're saying there is enough harm, right? That they've got enough things to meet the prima facie case that, straw on camel's back, whatever silly analogy you want to use. But I'm just trying to get how you're putting
I think
a
the court,
distinction here.
sorry,
Yeah, go ahead, yeah. I
I
think
think
we're
the
getting
core
to the same page.
point, the core point is, it has to, personal jurisdiction analysis has to focus on the context that the defendant creates with the state. Here, the allegation, even if we accept the allegation, it's the consumer who elects to sign up for the service that is, under the way the court was just reasoning that through, the consumer has chosen to sign up for a service here, but the contact that gives rise to the claim has to be the defendant's contact with the state. And the defendant's contact, for instance, in Ford Motor, it wasn't the decision of somebody, some consumer to buy the car. That wasn't what gave rise to the claim or related to the activities. It had to be Ford's own activities in the state.
Ford made those cars available in the state of Minnesota being one, right? And the state of Nevada is contending that Messenger was made available. We use Meta, but we're dealing right now with the Messenger case, right? available in the state of Nevada. So that's why I'm trying to get you to focus on, I'm fully appreciative that a truck is not an application,
I
okay?
understand you.
Okay, we're not talking the difference between a physical piece of art, right, and a digital piece of art, okay? I'm not going into nils or all sorts of other things, but just kind of have some concepts here, right? But that's the reason why this court's asking this question, and I'm not trying to change the focus to the consumers. I'm really focusing, right, on what was Messenger's via Meta's conduct, right, in the state. So does it relate to or rise from? And that's where I'm trying to get you to clarify what you're distinguishing forward here, other than obviously one's an app and, or an app, a platform, a service, whatever words you want to use, versus a physical vehicle.
In Ford, the claims related specifically to Ford's activities in promoting the cars in the state. Here, the claims relate to something different. They relate to the design features of Messenger. That's different from the activities. The activities here in the state are alleged to be, for instance, targeted advertising or users who decide on their own to download the feature. And to take it back to the Ford example, Ford didn't base the arising out of or relating to analysis on the fact that the consumers had bought the cars in Montana or Minnesota. It was what Ford was doing in the state. And here, the allegations are not of conduct in the state, contacts in the state that relate to the design features or that relate to the supposed misrepresentations. That's the difference. In Ford, you had activity by Ford to promote those very vehicles. Here, we don't have any allegations that link up these design features with any activity in this state. And the same for the misrepresentations. They're not linked to any of the contacts in the state.
I appreciate it, sorry, go ahead.
So then let me go on, Your Honor, that you had raised the question of whether Facebook and Instagram could properly be considered here. I think the answer is clearly no. In paragraph 30 of the complaint, the state alleges that Messenger is a subsidiary of Meta. And then at paragraph 38, the state alleges that Messenger is a freestanding app and freestanding website developed by Messenger, and it refers specifically to the fact that it's a separate messaging functionality from the main Facebook platform. That's what it alleges in paragraph 38. And the key, it's somewhat Hornbook law, I think, that the activities of one corporate entity are not attributed to others for purposes of determining personal jurisdiction. The personal jurisdiction analysis is based on the individual activities of that subsidiary, and here the state alleges Meta is a separate subsidiary, Messenger is a separate subsidiary, and so the activities of Facebook and Instagram can't be attributed to it. I don't think that's the key part of the analysis, but I did want to clean that point up for the court. If the court does not have more questions for me on personal jurisdiction, I'll turn quickly to the First Amendment and 230.
I do not think so.
Okay. On the First Amendment and 230 issues, I think it is incorrect for the state to suggest that the First Amendment and Section 230 principles are at odds with each other. They're actually complementary. The Moody case and the First Amendment principles recognize the ability of a social media service to engage in protected activity through its editorial discretion about how it is going to publish third-party content. That is consistent with Section 230, which recognizes protections for activity in publishing. They're not inconsistent, they fit together, because the whole premise of Moody is that a social media service publishing third-party content can be making its own editorial decisions about how it's going to publish that content. That aligns with Section 230 principles. I recognize the Third Circuit decision recently in Anderson came out the other way. There's Ninth Circuit law that goes exactly contrary to Anderson. But I think logically, they fit together. They're not inconsistent because they're both talking about this basic question of protection for publishing activity. Now, let me turn, if I may, to the discussion of Section 230. I think counsel was simply misstating this scope of Section 230 by saying that Section 230 doesn't apply because the state is not requiring Meta to change any of the third-party content it publishes. That's not the right test. The right test is that the state would require Meta to change the way it publishes third-party content. So it would require Meta to change its publishing activity. Take the example that the court raised of an infinite scroll. The state is suggesting that Meta can't properly do that, that Messenger is somehow engaged in improper activity by providing an infinite scroll. That's publishing activity. It's decision about how much content to make available, how frequently to make it available. And that question of how much Meta can publish in terms of content is protected by Section 230. 230 does apply to content, third-party content, but it's not limited that way. So I think the test that counsel articulated, that because they would not require Meta to change any of the content it publishes, they're outside the scope of Section 230, I would respectfully submit that's not a correct statement of the law, because clearly Section 230 extends to publishing activity. I think Lemon itself tells us this, because Lemon itself said that that case did not involve Snapchat's conduct, quote, as a publisher. But it recognized that if there were conduct as a publisher, that would be within the scope of Section 230. So I think Lemon reinforces the point we're making, and other cases that we cited, including Dyroff, recognize that Section 230 doesn't simply apply to third-party content, and the test is not simply would you have to edit or remove third-party content. The test is would you be forced to change the decisions you're making about how you publish. And that has a First Amendment protection to it because it's editorial discretion about how Meta publishes through Messenger. It also has a Section 230 immunity because, again, it goes to this question of how Meta is engaged in the publishing, the dissemination of content, and that is protected. And I think the court had previously raised this question of whether end-to-end encryption somehow is outside the scope of Section 230. I think it's clear that it's right in the middle of Section 230 because it's a decision about how content is being shared between parties. And it also fits within First Amendment principles because it's the editorial discretion that Meta engages in about how it's going to allow people to communicate with each other. Moody recognizes a protection for that, a constitutional protection. Now, the state had raised this question of Irwin v. State and whether that somehow should be controlling here. As the state described the case, it's clearly, it was a case involving deceptive conduct, deceptive telephone solicitations. We've not argued that the First Amendment applies to misrepresentations or deceptive activity. Furthermore, just by the very nature of the way counsel described it, that was proposing a commercial transaction. That was seeking a telephone solicitation, seeking business. That was very different from what we're talking about here. think, Your Honor, I've covered all these points, but I do, if I can finish on one point on purposeful availment. The case law is quite clear that simply the universal availability, accessibility of a social media service or a website is not enough to establish purposeful availment. And that can't be the contact that could somehow be said to give rise to any claim, especially when here what we're talking about is conduct by third parties in downloading the service. And then you have something very different from those. The downloading is not the nature of the claim. There may be ultimately harms that could be said to come from the fact that a user is exposed to the content, but that's not related to the claim. The nature of these claims is something very different.
And what is the difference that you're saying? Because they're telling me it's the same, you're telling me it's different, and trying to get some specifics here on why you're saying it's so different, right? Because you don't purchase the car, then you can't get injured in the car. If you, and I'm not in, there are other distinctions, but
Right.
trying to make it more simplistic, and I'm not changing the standard of them purchasing the cars, right? What I'm looking to is straight from the Ford language, right? That where the Supreme Court rejected the causation-only approach. As they said, the Ford's causation-only approach finds no support in the court's requirement of a, quote, connection, end quote, between a plaintiff's suit and a defendant's activities, and they cite to Bristol-Myers. So I'm going straight from Ford and not asking my questions. It's very easy.
Right.
So
I mean-
looking at that, you'll see where my questions are coming from, right?
The other thing Ford said, though, is, I mean, sure, it's not a strict causation standard. Ford rejected a strict causation standard, but also said that the phrase relating to incorporates real limits on personal jurisdiction. And they said, as it must, to adequately protect defendants' forum to a forum. And that's at page 1026, if the court's looking there. And I think it's a very important distinction we're trying to draw, because if mere harm to somebody in a state were enough, then there'd be no significance to this arising out of a relating to test. And they wouldn't have had to engage in the analysis they did in Ford Motor. They wouldn't have had to engage in the analysis they did in Bristol-Myers. Because in Bristol-Myers is another case where you have injury in California, harm in California, but that's not enough to establish that the claims arise out of or relate to the contacts in the state. And I think here, if it were simply harm, if it were simply the fact that users were harmed, then that would suggest there's no limit at all on arising out of or relating to if there's a national or an international social media service. That's why the claims need to have some more specific relationship. I hope I've helped the court.
Okay,
Thank you, Your Honor.
thank you so much. Well, folks, it's 12:05, and so here's the court's question. It seems to me, since I have Ms. Peterson standing up, she still would like to make a couple of points, and I need to address State after a law on my team getting their lunch break. So it seems to me I'm inviting you all back if people want to have additional argument, right, because I don't want to cut you all off, and you actually might want to hear a court's ruling, I don't know, maybe you don't, who knows?
Well, we would like to do that, Your Honor. I did have just 2 points I wanted to make, and I would make them very briefly, but.
Well, I've heard
But
those
if-
words
if-
before.
I beg your pardon?
I said, I've heard those words before, not from you, I'm just saying, right?
But I see my colleague wants to make some other comments as well, so
It's up to you.
perhaps.
If you all can get all of yours done in the next 4 to 5 minutes, that's fine, but then I'm gonna have to call you back if you wanna hear the court's ruling today. If not, you can wait for the court's ruling.
Yeah, Your Honor, my game for the state, I mean, Meta's had more than half an hour extra over us. We had like 3 or 4 quick points we wanted to make too. We would like to hear the court's ruling today, so our preference is to everyone have a lunch break and we should be back if that's fine with the court.
I mean, I'm offering you more time. If you don't want it, that's,
My colleague and I just have conferred, we have about 5 minutes between us, so I don't think that, but I'll defer, Your Honor. I mean, we were
so
just
you don't
trying to
have- You don't have
finish.
the court's ruling today?
would like to have the court's ruling
And that's
today.
not gonna, right,
Okay.
that might take more than 30 seconds, don't you think?
That's fine.
You have a lot of factors here. You
Your
want the
Honor,
court to-
would you permit Mr. Hester to?
Whoever needs to catch planes, and that's
Yes,
the issue,
because
to
he's
catch
in the
planes,
middle
that's
of a
fine.
trial right now, he came back for this hearing,
You
so.
all picked today, I mean, seriously, folks, you specifically picked today, this was not, as you, some people might appreciate, this is I have a very, very busy week this week with some very, very large cases. I'm just accommodating each and every case that wanted to be on my docket this week.
And we did pick this date because it could fit in his trial schedule, but he does need to get back for tomorrow.
The state certainly doesn't object, Mr. Hester.
That's, please, counsel, if that's your issue, go catch a plane, okay?
All right,
And
Your
it
Honor,
doesn't-
well,
it doesn't
I'm
make
sorry
any-
about that. I'm in the middle of trial. Today was an off day, but I have a witness tomorrow morning.
No worries, doesn't have, it's perfectly fine from the courts. See, that's if I had actually held you all to your, right, 45 minutes in your half hour, you've been out of here before now. So it's up to you all. Do you want to come back? You want me to pick a different date? Or do you want to wait for a court's ruling? I mean, folks,
I think it would be helpful to know the court's ruling today because we have another hearing scheduled, I think.
The state would prefer to go downstairs, eat some lunch and come back.
That would be our request, Your Honor.
okay, so for those who need to leave, you're more than welcome to leave. Okay, for those who want to stay, we will welcome you back at 1:30, okay? Thank you so very much.
Thank you, Your Honor.
Defense was going to finish up their replies or rebuttal arguments, however you'd like to phrase it, so go ahead, Ms. Peterson.
Thank you, Your Honor. Yes, thank you for the break. I did just want to address very briefly 2 points on the deceptive trading practices claim. After hearing my colleagues from the state argue that, I first wanted to talk specifically about the statute and the statutory construction argument that I alluded to, because the state said that they are under section 15 of 5980915. And that statement there, I think they're trying to use that as a catch-all, but they say, well, that doesn't specifically require a sale or lease or anything like that. And actually, that's not what the statutory construction of that entire statute, that's not how it works. There is a Latin phrase, and I am reminded of my father, who was way better at saying Latin phrases than I ever was. But it is the ejusdem generis rule, and that is, for your court reporter, I'll spell it EJUSDEMGENERIS. And that is a rule of statutory construction that means, loosely in Latin, of the same kind. Justice Scalia and Brian Garner had a book, Reading Law, which ever since I saw Justice Hardesty refer to it in his opinions, I made sure I had a copy. But they explain that statutory construction to say that when general words follow an enumeration of two or more things, then those general words apply only to the persons or things of the same class. So when I look at the statute 0915 and I see, subsection 1 say goods or services for sale or lease, and I see, the next one say goods or services for sale or lease, and I see it all down the line, goods or services for sale or lease, goods or services for sale or lease, goods for sale or lease, goods or services for sale or lease. Then when I see subsection 15 that says in a transaction, that transaction there is actually referring to this concept of things that have been specifically mentioned. Justice Scalia and Brian Garner actually have a great example. They say, if you had like a list like, hey, Mickey Mantle, Rocky Marciano, Michael Jordan, and other great competitors. Well, what would that word mean, other great competitors? Could you put, Napoleon Bonaparte in there? No, you can't. You're talking about athletes. It's of the same kind. And so when we're looking at this statute, and we're using the statutory construction of justum generis, then we can say it's of the same kind. So transaction means goods, services for sale or lease. Now, I'm not the first person to say this, of course, because Judge Mahan over in federal court actually found that this statute, subsection 15, pursuant to the doctrine of justum generis, the court construes the broad descriptor transaction as limited to the specific types of transactions involving the sale or lease of goods or services. So that statutory construction then brings us back to the issue that we're talking about here, when why the statute can't apply in this case. Goods or services for sale or lease, as I said before, this is a free service. There is no good or service for sale or lease here. And I heard the state say, well, user data is very valuable. And again, as I alluded to earlier, the cases say that just the ability to collect data is just not enough to say that there's suddenly consideration that would apply. And I'm gonna just give you a couple cases where that has been found. The mere, and I'm reading a quote from Inri Yahoo Customer Data Security Breach Litigation. It's a 2017 case out of the Northern District of California. And this is the quote: the mere transfer of personal information renders plaintiff's use of a free service or lease, and it says that has been rejected. So that theory was rejected by the court. There was another court in New Mexico that said just downloading and using these child-directed apps is not a sale, lease, or rental, even though the apps collects personal information. That New Mexico case is New Mexico X-Rail Balderas versus Tiny Lab Productions, and we cited one other case in our brief, also from the Central District of California, that stands for the position as well, that exchanging this personally identifiable information for use of a free social networking application is not a purchase or lease. And that case was the Zinzig versus Snap, just 2024, earlier this year. So with that, Your Honor, the idea that user data that is being collected, that courts have rejected that is not enough to transform this into a good or service for sale or lease. And I'll cede my time to my colleague.
It's a private question.
Okay.
And do you happen to have it up? Because I'll read subparagraph 11, right? Because from your argument, part of the reason I was confirming with
Of the statute, yeah, I have that.
Okay, C11, advertise goods or services as being available free of charge with intent to require payment of undisclosed cost as a condition of receiving the goods or services. How are you saying, I fully understand your statutory construction argument, but to the extent that you're saying there needs to be a sale or lease, doesn't subpart 11 infer that you could also have a representation about the cost of the product, or
Well,
use
if
it
we are
towards the
trying,
good or service, to use exactly.
if we are trying to find things that maybe somewhere, somehow, somebody could allege, I see where you're going with it, but Judge, the state is not saying that Meta says we're gonna allow these free of charge, but we're gonna have these undisclosed costs later.
Right, the reason why the court was asking the question, to finish off why the court was asking the question, was because, see, part of your argument is there needs to be a sale or a lease. So contained within the statutory language, there's also a concept of free of charge. I'm not saying that they allege it in their complaint, I'm just trying to say, how does that apply?
I think that's the ex alterius exclusio. It's the language that is specific applies, and in that case, that subsection says, when you advertise a good or service as being available for free, but then you intend to require undisclosed costs as a condition of receiving those goods or service, then it falls under the statute. Now, I would just say that if there are also hidden costs, that is part of a good or service for sale or lease under the statute. So the express language in that subsection would be a carve out. It is not It is not what the state is alleging here. When you have the general language in subsection 15, you are gonna have to require that goods or services for sale or lease.
Appreciate it. Council, you wish to address some of the other claims?
Yes, Your Honor, David Sneed again for Meta. I have only three quick points in rebuttal to what the state put forward on the issues that I was arguing. The first is in relation to the product point. And I wanted to come back to also one of the points that one of the questions that Your Honor asked me. The reality is that Meta, as a provider of services like Messenger, Instagram, and Facebook, could be sued in all manner of cases as a provider of those services. There are numerous types of claims that Meta could be sued under. Negligence was one of the ones that we talked a fair amount about, but there are other types of claims that individuals or government parties could pursue Meta about for their providing these services. There's intellectual property types of claims, patent, trademark, there's antitrust types of claims, there's class action, kind of economic types of claims. Particularly, there could be breach of contract type of claims if there were allegations that there was a contract that had been made by Meta with an individual or with an entity, and they could be pursued despite the fact that they are providing these types of services. So there are a wide variety of claims that could be pursued against Meta despite them being a provider of services. But I think the point in this case is that particularly for these strict liability, product liability claims, that are being brought by the state has to be able to say that the legal framework for those specific type of claims apply here. And that novel type of claim has not been established in the law of Nevada. And we've gone through a variety of cases nationwide that also question the expansion of product liability beyond the definition of product as reflected in that second restatement that we talked about. And so the claims here are simply not cognizable, even if there are other types of claims that Meta could be subject to. And with that, I wanted to address the second point on the product liability issue, which is what we heard from the state in response to the argument I made about Nevada law, about Schuler, about the legal analytical analysis and framework that courts use, is to say, we have a whole bunch of paragraphs in our complaint that use the term, where people have used the term product. And I'd simply submit that the US Surgeon General, a third party that used the term product in relation to services that Meta provides, I'm not even sure relevant to Messenger, but that these statements have no bearing on the legal analysis of what is a product under product liability law. We still haven't heard any answer to justify the analysis. It's as if, I could take patent, for example, if there was a person whose job inside of Meta, they decided, we're gonna call you, you work on patent, and you use the term patent in your discussions. Using the facts that people are called that, or people use those words, aren't the facts that actually allege that there was a patent. Those facts would be, you went to the Patent and Trademark Office, you went and you made an application, you got a response. These are the facts that are relevant to the legal analysis as to whether or not something is a patent. Just like with a product, there are facts that could be alleged that would be relevant to the legal analysis, and the state's answer to say they allege facts is merely to say that people use the term in the normal course of how people use that term inside the company. And the overlap between what is a product that the court has to analyze versus what a product is that people use in their terminology are two separate things. So the state hasn't come forward with what they need under the pleading standards to be able to allege that this is a product for the purposes of the legal analysis.
I circle you back on that a little bit. So you can, is Messenger's position / Meta's position that an app is not a product, or just the Messenger app is not a product? Or some third option that even if an app could be a product, it doesn't comport with the current Nevada standards of what can be subject to product liability analysis or cause of action, or some for a fourth option, not limiting you to those three, but those seem to be the top three that you might be going for, but let me hear which one you are.
Well, I would say that I believe all of those statements that you just made are likely true, but I don't want to eliminate any possibility for any app whatsoever. But what I can tell you is that the analysis that was put forward here is that this app is intangible. There is no tangible part of it. And under Nevada law, it looks to the restatement as the analytical framework by which we will determine what a product is. And so I think under the current Nevada framework, the state hasn't come forward with the facts relevant to allege that there is a product here. So I think at the very least, that answers the question for the purposes of our case. I do think, and I'm not aware of, a scenario where there is a tangible component of an application that would make an application into something tangible enough to meet the definition and the examples that were put forward there. But I can say for this case, there's no question in my mind that the state hasn't put forward the facts that would line up the analytical framework with what product liability is, and that's based on the Schuler case's analysis.
The reason why the court's having this challenge, right, with what, I mean, the good news about excellent oral argument right on either side and excellent briefing is, guess what, raise questions, right? You go to the app store, regardless of what format you have, right? So you go to the online store and you can order or download, however you want to phrase it, right? If you're going to one online store, you can order certain things that get delivered, right, to your home maybe, or your office, or it's a gift for a friend, right? And then you go to a different one. Okay, I don't play it, but some people told me Candy Crush has in-app purchases, right? So, and I'm just picking games, I was trying to think of game purposes of this, right? A game where people can play online, and they may not pay for the initial, but they have to pay for other things, or to go certain parts, or to go farther in it, or maybe they're paying for the whole thing. That's an app. Messenger, right, seems to be agreed that there's no upfront cost. There's a disagreement on whether or not the data can support consideration. I'm not getting there right now. But, so that's why I'm asking the questions. Are you saying that certain apps, that if you're ordering something online through an app, that it can't be subject to product's liability, right? Because remember, they're going failure to warn, and they're going design defect, right? Which ties into the concept of a product. An app does have code, and so if you're going through that kind of concept, I mean, say somebody did an app that told you how to, I don't wanna, today's a very bad day for me, I'm not gonna use that example, for me to use a particular example, but say for some inappropriate illegal conduct, right? How to make whatever, or how to do something, or are you saying that there could be no product liability there because it's an app? By the nature of calling something an app means that there's no liability under product's liability? I'm just trying to see where your argument is, if you don't mind.
What I'm saying is that product liability is meant to address the problem of liability from personal injury that arises from a product. So in the example where a company manufactures a product, and let's say they have an app where they sell that product. If they manufacture that product and they sell that product to you, regardless of how they sell that product to you, whether you go to the store and buy it, or whether you go and you buy it on their app, it doesn't change the reality of they manufacture a product, you purchase that product, and the manufacturer could be subject to product liability claims if you are injured by that product, because they have done that. So the nature of the app
Which is
itself.
why I gave you the game example, or I can give you another one, right? Let's change the old-fashioned radio example, right? Where people were told to get to point A and point B, right, for different contexts, right? And then got in car accidents, or alleged, right? Or doing speedy driving, or whatever they may be doing. If there's an app that kind of tells you where these things are, and it encourages you to drive 100 miles an hour to go get some place. Now, I appreciate that there's gonna be a negligence claim, it's gonna be part of your response, but are you saying that's not a product? I mean, I'm trying to figure out where this potentially slippery, so potentially gray area, or maybe it's clear cut from you all's position. I'm just trying to get a better understanding of what your client's position is on this.
Our position is that if you look to Schuler and you look to the second restatement for understanding what a product is, because the question, that the Court of Appeals was answering in that case was whether something was a product. In that case, it was a large sign that they decided was a product, ultimately. The analysis that the courts looked into was to say, well, okay, well, what do we use to be able to determine what is and is not a product? And they looked to the second restatement and said, we don't need to have a definition that works for every case, but we're gonna look at the second restatement, and on a case-by-case basis, we're gonna analyze whether something is or is not a product. And when you look at the examples of things that the court ultimately said was a product, they look at the listing, like what I was talking about before, of tangible items that can be purchased and could potentially be alleged to cause an injury. If an item does not qualify, like software and like code with an application, does not qualify as something tangible that could result in such a personal injury, then under that analysis, under the law, those don't qualify as products, even if there are a wide variety of ways that someone could make a claim against a company that are to pursue, whatever justice they're seeking, like negligence, for example, or like we were talking earlier, like if there's a contract between the individual and the company, they could say you breached the contract because you provided me something that was not in line with what you said you were going to provide me. But none of that has to do with product liability, which is a framework that developed for a particular reason. The idea being you could assert strict liability against companies that were manufacturing products and putting them out and giving and selling them to individuals to redress the concerns and the risks of personal injury and not make the individuals that are making those claims have to prove up the kinds of elements that you have to prove up with negligence. That's not applicable, and no court in Nevada that I've seen has said that it's going to be applicable to something that is intangible when the analysis under Restatement 402 says otherwise. So it's our position that it does not apply to this application, does not apply to Facebook, it doesn't apply to Instagram.
It's not those places that
I don't mean
mentioned,
to
right?
ask that, but.
Because then they're gonna tell me, guess what, he mentioned it, and we get some additional argument, right? And
I don't think it's a surprise that our position is the same across these services. And it's not based on what instructions the act tells you or what potential harms could arise from information that you see or learn on the app. It's the nature of the application itself as compared to the nature of things that have been established as products for the purposes of the law that would subject the company to the strict liability framework as opposed to subject the company to other kinds of legal frameworks that they could be facing, like contract and negligence otherwise.
Good, bless you. Are you saying that there was I didn't see any case really cited by either side that was directly on point. I'm saying an app is or is not a product under any state. You can say that somewhere in several hundreds, about almost 1,000 pages, that it was in there?
I am not saying that there is a Nevada state.
I'm talking any case, and you all have given me lower court cases from lots of different jurisdictions, so that's why I was, both sides have. I mean, it's not a negative, I'm just saying it's a reality, people to.
That's accurate. We believe that the way the case law in those other states reflect that intangibles, like software, like these applications, like these services, do not qualify as products for the purposes of product liability. And there are cases nationwide that we pointed to that kind of support that point, but I think what's most helpful is they're aligned with what the restatement says, which is how Nevada analyzes these claims.
Okay, go ahead, please.
The last thing I just wanted to mention was just the point about proximate cause and our arguments about proximate cause, just very briefly. The point that I was trying to make in an initial argument was not that there's something that's so obvious as was stated by the state. Rather, the analysis, again, going back to the analytical framework under the law, it is about looking at, in proximate cause, the actions of the defendant versus the actions of third parties. And the cases that we pointed to reflect that in this kind of instance, where the allegations depend on the actions of third parties, who are actually the ones that are the sources of the content that the state is making claims of the harm arising from, then Meta, in this instance related to Messenger, is not responsible for every one of those steps as reflected by the complaint, because the third parties are the ones that are providing the content. So that's the analytical framework for how to approach the proximate cause argument that we put forward.
I appreciate it. Okay, here's what, I'm still having some challenges with the product, so I think the fair thing to do is I give 2 minutes to the state if they want to respond to the product and give you last word on that.
Thank you.
Unless somebody's gonna say that I shouldn't, if somebody tells me I shouldn't, I'm gonna leave it right here and I'm gonna make a ruling. Since I've indicated I want to, probably you might want me to, but.
No objection.
No objection, counsel for the state, do you want 2 minutes to explain how it's a product?
Michael Gayan for the state. The only thing I'll say again is we're here on BuzzDo, it's a 12B. There's, I think I made a good record, and it's in our papers, that there's allegations, there's no clear law foreclosing this theory in Nevada. They're trying to fit it into existing case law. I think the digital space is new and courts are always a little behind. So at a minimum, there's no binding law requiring dismissal, and under the BuzzDo standard, I think we've alleged sufficiently facts to support letting it go forward. And while I agree that ultimately whether it is a product is a question of law for the court, it's clearly a question of law influenced by facts and information. And to foreclose the state from ever pursuing these claims without doing any discovery into more of what Meta is doing and what goes into the messenger platform, so the court can make a fully informed decision, I think would be improper, and we've briefed that. Getting down into the nitty gritty, I don't know that I have anything more to share on what it is. It's just I believe that is evidence that we should move forward, do some discovery, let experts weigh in, let whatever, have some more information for the court before saying that it's barred. Thank you.
Okay, counsel, you get last word, or pick that if you want it.
All I'll say is, the facts that have been alleged don't go to the tangibility, intangibility, or any factors that are in section 402. And that is why it can't meet the test to avoid dismissal at this stage, even at 12B stage. Hi. Thank you, Your Honor.
Okay, so, well, thank you again for the excellent briefing, excellent oral argument. Here's the court's ruling. First, I'm going to address personal jurisdiction. As stated, the parties are not contending with general jurisdiction. The court's not going to address general jurisdiction. The court's going to go straight into specific jurisdiction. And to do so, I'm realistically going to read from 2 cases. I'm not going to do all the citations. I'm going to paraphrase certain aspects. So from Ford Motor, specific jurisdiction covers defendants less intimately connected with the state, but only as to a narrower class of claims. The context needed for this kind of jurisdiction often go by the name, quote, purposeful availment, end quote, citations omitted. The defendant, we have said, must take, quote, some act by which, bracket, it, bracket, in bracket, purposely avails itself to the privilege of conducting activities within the form state, citation is omitted. The context must be the defendant's own choice and not, quote, random, isolated, or fortuitous, end quote, citations omitted. They must show that the defendant deliberately, quote, reached out beyond, end quote, its home, dash, by, for example, quote, exploiting, oh, so it's exploit, bracket, T-I-N-G, end bracket, a market, end quote, in the form state or entering a contractual relationship centered there, citations omitted. Yet even then, because the defendant is not, quote, at home, end quote, the form state may exercise jurisdiction in only certain cases. The plaintiff's claims, as we also stated, must, quote, arise out of or relate to the defendant's contacts with the forum. Citations omitted. Okay, or put a bit differently, quote, there must be an affiliation between the forum and the underlying controversy, principally an activity or an occurrence that takes place in the forum state and is therefore subject to the state's regulation, end quote. Actually, that one's Bristol Myers, okay. So then it goes into the analysis on the policy behind that, the 2 sets of values, okay? Then we go straight to Tricarci. In Tricarci, the Nevada Supreme Court goes on to say, specific, quote, specific personal jurisdiction is proper only where a cause of action arises from the defendant's contacts within the forum, end quote, citations omitted. In evaluating specific personal jurisdiction, courts consider two factors. One, whether the defendant purposely availed itself of the privilege of acting in the forum state or purposely directed its conduct towards the forum state. And two, whether the cause of action arose from the defendant's purposeful contact or activities in connection with the forum state, such that it is reasonable to exercise personal jurisdiction. Citations omitted. In analyzing whether specific personal jurisdiction exists in a tort action, courts apply the quote effects test, end quote, derived from Calder versus Jones, citations omitted, which considers whether the defendant, one, committed an intentional act, two, expressly aimed at the forum state, three, causing harm that the defendant knows is likely to be suffered in the forum state. Citation omitted. Thus, the plaintiff's contact with the defendant and the forum are not the proper focus of jurisdictional analysis. Instead, the effects inquiry and the question of minimum context focuses on the relationship between the defendant, the forum, and the litigation, and the, quote, defendant's suit-related conduct, which must create a substantial connection with the forum. So then it goes into the example it cites to Walden, right? So then it talked about Walden with regards to the Georgia police officer, and there it focused on, the court emphasized that, quote, first, the relationship must arise out of context that the defendant himself creates with the forum state. And second, the minimum context analysis looks at the defendant's context with the forum state itself, not the defendant's context with persons who reside there. And then it goes into, one second, please, Walden. And gives the analysis of Walden. So, one second, please. Okay. So then it talks about that the proper question is not whether the plaintiff experienced a particular injury or effect, but whether the defendant's conduct connects him to the forum in a meaningful way. To illustrate how this effects inquiry works, Walden pointed to the facts of Calder, where a California actress sued a reporter and editor for defamation based on an article written and published in a Florida newspaper. Citations omitted. Calder held that California had jurisdiction not because the actress suffered injury there, but because the tortious conduct occurred in California, where the reporter had gathered the information from sources in California about the actress's activities in California, and the article was widely circulated in California. So now we have to look at those prongs as done to this case. So first prong, right, parties agree is purposeful availment. So here it is contested whether or not there was or was not purposeful availment. Well, while Ford, it was not contested, there's some key language in Ford that guides this court in its determination. And that's going back to what the court read a moment ago with regards to exploiting a market in the forum state or entering a contractual relationship centered there. Here the court does find that Messenger has, quote, exploited a market in the forum state and has also entered in contractual relations centered there for a motion to dismiss. Remember, I take the allegations as true, so I'm not making those as affirmative determinations, but I'm making them for purposes of the pending motion. So that means the court does find, and if you want all the citations, it's citing Ford, that cites Walden, and cites Calder. So, and then also Tricarci would be consistent there with. So the first prong is the court does find that there was a purposeful availment. The next part is, was the conduct arising out of or relating to with regard to the claims at issue? And here, the court does have to look at the numerous allegations in the complaint and to see, are they tied? Are they like the Calder example that was cited in Tricarci with regards to the article in California Research and everything? Or is it more like how they determined in Tricarci that those issues were not present? And here the court finds that there was conduct, that defendant's conduct arising out of or relating to is the issues in the underlying complaint. Now, the court does not have to, remember, I have to assume for purposes that the allegations in the complaint, right, the truth of the allegations in the complaint. I also have to look at, remember the standard, I'm looking at both of these prongs, remember, prima facie, that's straight out of Tricarci. And I'll do the citation, we are, one moment, right back to it. Mr. Carchi states that needs to be on a prima facie basis. So I have to look at it as a prima facie basis based on the allegations, based on the conduct asserted, giving the opportunity of, and to be clear, I'm only taking this into account for Messenger. I'm appreciative, I've got an omnibus opposition. I'm not taking the factors of Instagram and Facebook into account for the purposes of this analysis. I'm taking this section, which is a separate section in the opposition that went to the aspects for Messenger. And realistically, adopting the paragraphs that are in the opposition, I'm adopting which references specific language in the complaint. When I go to all of that, the court does find that there has been conduct rising out and relating to. So, and some examples of that would be when you look at the tie-in, the actual cause of action in the complaint with regards to the conduct asserted. Now, with regards to purposeful availment, I could have gone back to the app, download the citations to Picoli and those factors as far as also with regards to the testimony from the various witnesses presented to this court, which the court can take into account because that was at your first hearing, right? Court ordered jurisdictional discovery, still part of this motion to dismiss. And I look at the totality of the witnesses' testimony, totality of what has been presented after the jurisdictional discovery and the appendices is incorporated in the opposition as well as the applicable case law. The court does find that this situation is more like the Calder situation because of everything that's being asserted happened in Nevada, that it's not like Tricarci. So therefore the court finds that that second prong is met. So then the third prong is defendant would have the burden to see that for some reason the particular jurisdiction right would not be fair play or substantial justification. Once again, we go back to Tricarci for this one. A moment, please. So the court did find that Messenger reached out in Nevada, so it's intentional conduct. It's not the conduct of people who are doing things here. I don't want the court to be misconstrued in that regard. Okay, so then the court now has to look to see if it's consistent with fair play and substantial justice, right? Citation section 11 in Tricarci. Analyzing whether exercising jurisdiction over a defendant who had sufficient minimum context with Nevada was reasonable. The cites to Trump. Trump observes that the plaintiff establishes that the defendant purposely availed itself of the privilege of acting in Nevada and the cause of action arose from defendant's Nevada activities. The burden then shifts to defendant to set forth a compelling case that jurisdiction would still be unreasonable. And at this stage, from what's been presented to this court, the court does not find that defendants have met that burden pursuant to Trump as cited in Tricarci, and so therefore all the factors of personal jurisdiction have been met, and this court does have personal jurisdiction. So that goes for your, and I can cite to NRS 14, right, 065 with regards to the Nevada's long-arm statute. So then that means I go from the first part of the 12B motion now to the 12B5 portion. The 12B5 motion goes into the actual causes of action that are presented to this court. When I look at the actual cause of action presented to this court, the court finds as follows. I'm going to do the order that they were argued to this court. So let's go first to the 598 claim. The 598 claim, I'm going to grant the motion to dismiss, but with room to amend. Realistically, this probably comes as a surprise to anyone, the court has concerns whether or not, as pled in so much of the incorporation language, if they really are articulating a product, sale, lease, right, etc., under 598, or if they're trying to do an extension of the current case law under 598. So I do find leave to amend would be appropriate at this juncture, but I do find a motion to dismiss should be granted with a 598 claim. So then let's, I should have circled first to the 230 and the First Amendment. My apologies, let me circle back to that. First Amendment claim, I do not find the First Amendment bars it because at this juncture, what has been presented to this court, once again on a motion to dismiss standard, is the court does not see that as the actual language, publishing, speech of Messenger in a context that puts it within the First Amendment based on all the case law cited by each of the parties. Because, and when you're looking at what has been presented with regards to the First Amendment complaint, it's as stated in the allegations, that those allegations are not going to the content. And whether or not that ultimately plays out in subsequent pleading practice, the court can't rule on what may happen down the road. The court has to look at a motion to dismiss standard. So when we look at the motion to dismiss standard, what's actually there, not the party's interpretation of what is there, the court has to find that First Amendment has not been met. So then we go to the 230 claim. So then we go to the 230 claim. And here, you all had cited, we go to Lemon, right? So Lemon is instructive. Lemon walked through whether or not the kind of publishing concept, and is it the third party, is it purely, is it publishing, is it third party speech that somehow would preclude these claims? Realistically, has been presented to this court, the court doesn't find that it has been established that it would have fallen in 230, because the court is looking at the allegations and the complaint. The court is looking at with regards to whether or not this is a prohibition of the publishing of speech, as well as the, what is it? So the language I'll use, 1 second, please. Whether it's how meta, for the First Amendment, the court doesn't agree that it was First Amendment speech, because it doesn't agree that, at least as currently presented in the amended complaint, it was how Meta organized and displayed its content. The court really sees it as third-party content and what is being asserted with regards, so it's not Meta's actual speech as set forth in Messenger. And particularly there, the court does look at one of the allegations with regards to the end-to-end encryption, which is why I have some questions on the end-to-end encryption, because that is a method by which who has possession of content subsequent to, it's not the actual content. And so when I look at all of that, I go back, circling back to First Amendment, that would be First Amendment. So then you go to 230. So the 230 analysis, it was stated that there was an addictive, harmful design features, right? And the question became whether or not that is something that is just republished by Messenger, and therefore it would be under some of the protections set forth in Lemon, etc. And cited to the Snap case, or whether or not it is something different. The court really finds that based on the allegations, they're looking at the conduct, not the content. So I don't see the application based on Lemon, Snap, etc., how that claim would preclude the complaint, First Amendment complaint in its entirety. So, just 1 second before I move on to the state claims, but make sure I have everything that I have pointed out here. 1 minute, please. If you all wanted me to circle back to some of the, just make me one note, please. this now. Okay. So, I've walked through personal jurisdiction, and I've walked through the prima facie standard, I've walked through the analysis under Ford and Tricarci. I then walked through the analysis under First Amendment, and then the courts walked through the analysis with regards to the 230 claim. I started to go through the 598 claim, and when I adopted, I said a few moments ago with regards to the 598 claim, I grant the motion to dismiss with leave to amend for the reasons stated. We do have concerns about how the complaint is currently pled with regards to its application of 598, but I can't find that there's no set of facts whatsoever that would not fall within 598. I think you both really conceded it. There's not something currently that is precedential in the state of Nevada that really addresses an app of this nature and how it would really be viewed either as a product or not, whether or not there's going to be some value in how you take, the sale and lease and how you really take that language. So that's why it's granted with leave to amend, because I think that's the more appropriate way to do that one in light of those factors. So then we go to product liability. And when I use the term product, when I was using Nevada's Deceptive Trade Practices Act, I was not using it in the term of a product for a product liability claim. I was using it in the term for a product, because you guys have used all sorts of words, and so there has to be something, right? There has to be, whether it's a transaction, whether it's a product, et cetera. It's not clear what's really being asserted is the action that is subject to the 598 claim. Might be a more clearer way of saying it, okay? So it's not to be confused with my analysis on a product for a product's liability claim. So now let's get to the product's liability claim. Well, no surprise, I'm gonna say the product aspect for a product's liability claim is similar to the lack of clarity under the Nevada Trade Practices Act, so 598 claim. So when I'm now looking at the product liability, while I do see that there is a lot of testimony, except from the various witnesses back from when we had the hearing, but also in the briefs, as to there being a product. There's language in their own terms of use that it's a product, and if you can't hold a company responsible for how they're phrasing something, I mean, at least on motion to dismiss standard, therein lies an interesting challenge. However, it would be, plaintiff has to at least allege enough that it fits within a current cause of action, right, or reasonable extension for a cause of action. I just don't think that there's enough here at this juncture, so I'm going to grant the product's liability claim dismissal, but also with leave to amend. And the reason why the court finds leave to amend would be appropriate, part of what I said previously also applies to the product's liability claim, and the fact that whether in today's digital age, whether quote, a product has to be something hard and fast, does it have to be a ladder, does it have to be a car, does it have to be something like that, or can it be something that comes across digitally, right? Particularly when you have a design, they're both got designs, they both have potential warning aspects, they both have content, and so there's not something that is clearly articulated whether that would or would not fall within current Nevada law or a reasonable extension of Nevada law, which is why I'm granting the motion to dismiss, but giving leave to amend on a product liability claim. With regards to the negligence claim, the court's going to deny the motion to dismiss on the negligence claim. Realistically here, I'll go to the reverse order. The proximate cause issue really is an issue of fact. It's applicable case law that you all decided. It's not so clearly deficient that the court can find that to have an asserted approximate cause analysis. The court is very cognizant of Buzz2 and how broadly Buzz2 has been read, and how broadly, more recently, our appellate courts have kind of defined what can and cannot be in negligence and what are subcategories of negligence. And so when I look at that, I would need to do it. So now I need to go to the duty prong. The duty prong, well, realistically, it's asserted that there is a duty. So on a motion to dismiss under 12b-5, there's at least enough there under Buzz2 to put the defendant on notice of what is the quote duty. Now, whether or not it's a sufficient duty, whether it's a recognized duty, that's stay tuned for something down the road potentially. If something comes before the court can only address right issues. And so when I look at the current case law, since the only two problems really this court was asked to address was the duty and proximate cause, that's what the court has addressed, and I do find that the motion to dismiss should be denied with regards to negligence claim. Unjust enrichment. You all really didn't talk much about unjust enrichment, but herein lies a challenge on the unjust enrichment. Based on the pleadings and in this case, I'm really gonna grant the dismissal and give leave to amend to see whether or not the state can be asserting this unjust enrichment claim, because it's really not saying what actually, for the state being the actor, because right, it's a secondary role, how we really get to your unjust enrichment. It's just not clear. I understand that this has got a lot of different language, but I don't see it's really clearly articulated in there, so I think it's appropriate. And then granting leave to amend with a couple other cause of action, it makes sense to grant leave to amend to this cause of action. Circling back, just one moment, there was a question. I dealt with the COR exchange and I dealt with the consideration of, in my analysis of the 598, I did incorporate the concept of the consideration issue was incorporating what this court's comments were when I was talking about the sale or lease, because that also ties into the fact about whether or not there needs to be consideration or not. Now we need to go to the 9B standard, which I probably would have got asked a question if I didn't address whether or not 9B goes to a 598 claim. Realistically, since I'm giving leave to amend, the court really doesn't find that I need to address whether or not it's pled with such particularity, because we're gonna stay tuned and see what actually gets addressed in that claim, and I could address the standards at that juncture, because it has the other failure. The court doesn't have really, I don't find that I need to get to the standard of specificness. And yes, I'm appreciative that there's numerous paragraphs that go to whether or not those numerous paragraphs have date, time, et cetera, and whether or not those are specifically required, or whether there's an exception under the two statutes cited. I really find that that doesn't need to be addressed, like I said, because the court finding they already had the other issues which would require it dismissal to be granted and then leave to amend to be granted. I believe I've gone through all the causes of action. Let me circle back to see if anybody has, that's the court's ruling, it is so ordered, so then we would need to determine for when you're gonna get the order to the court, when you're gonna want your leave to amend date to be, after. And in light of where you are with other things, if that impacts anything else the court's about to hear. And if people need to leave, feel free to do so, no worries, I know people have flights and things like that, so we can address these other issues. Before I get there, is there, I'm not seeing anyone jumping up and saying that they need some point of clarification, so I'm really giving a few that I've incorporated what I need to incorporate. Now, if you all want me to go back to your pleadings and cite every single case that's in your pleadings, that's why I just have incorporated the arguments in the case law and given some general case law citations. Counsel Burkline, if you're standing up, what may I do to assist you?
Yes, Your Honor, Michael Gayan for the state. I'd just like to know which party the court would like to prepare the order.
Oh, well, that really I was gonna see, with you all, I'm sure that, I mean, technically if defense wants to, since I granted it in part and denied it in part, they actually have the opportunity to do so first. This court doesn't have a preference. I really would leave it up to the parties. If one side is, if they're both volunteering to do it, then I have to say defendant gets to do it because I granted in part and denied in part. If they don't want to do it and they want the state to do it, then I'm fine with that too.
We'd be happy to draft the order, Your Honor.
It's meant to opposing counsel provide it back to
Yes,
the court.
of course. I'm just
EDCR
thinking,
7.21, are you about to ask me for additional time versus the 2 weeks under EDCR 7.21?
well, I think that might be appropriate. We'll ask for a transcript of this hearing. We'll try to get that as quickly as possible, but we may need some more time past that 14 days for the order. I'd ask for 21.
It's fine with the court if it's fine with all parties.
That's fine for the state, Your Honor.
Okay, so then leave to amend, how much time after the signature of the court, right, and notice of entry of the order do you need for leave for your amendments?
Look at my calendar.
And you want it triggered from the NEO, or you're requesting the amendments to be triggered by some other date?
From the NEO. Let's see. So I'm just looking at the calendar. I would say at least 2 weeks, Your Honor. We put us in the second week of November, I believe.
Okay, remember, Okay, so you want 14 days from NEO, is that right? To file your amended pleading, if you choose to do so?
Yes, Your Honor.
Does that meet the needs of counsel for defense?
That would be fine, Your Honor.
Okay, so that takes care of that aspect. Shall I anticipatorily say that since you've only asked for 21 days, that if you need up to 30 days to get the order in, anticipating that you, or should I just leave it at 21? It's just, normally when I say 21, when you all tell me 21, then I get a stip about a week later that says, can we really have more time? So
I was
might
kind
as
of
well ask you
wondering the
now.
same thing. I think the state would be fine if we just do 30. I think it's,
That would be great, Your Honor, thank you.
you can always get it in earlier.
Right, I was just gonna say, if we're really on the ball, we can get it in earlier, but 30 days would be terrific.
Okay, and 14 days from the 30 days. Okay, so now I need to ask you all the practical question. Remember, technically, this case has one case number consolidated, but you specifically asked the court to hear these motions separately on 3 different platforms, programs, however you like to phrase your products, okay? So, you know where you're coming back next to this court. Is that gonna meet everybody's needs? Or is anybody going to ask this court potentially for a different date because maybe you want, this is not, the court's fine with the date, let me be clear, okay? And to be clear, just so we're clear on what date we are talking about, for anybody, remember you're coming back on the 15th. Today already being, right, the 7th, I'm not sure what you all want. I am perfectly fine to hear the other 2 motions on the 15th, I've got you blocked out for the 15th, but I'm not sure if either A, you wanna tell the court now something, or B, you wanna talk among yourselves and decide what you might want to do, and then I have to give you a deadline to let this court know, so I'm, as much as I do enjoy re-preparing for things over and over again, there might be a few other things on my plate that I also need to prepare for.
Your Honor, Michael Gaines for the state, we would prefer to keep the October 15th hearing.
So would matter, Your Honor.
Perfect, okay. That's fine, I just didn't know if you all needed to transcript.
Could you
for-
remind me, did we have a special setting for the October 15th hearing as well?
I don't know that,
Hold on one second.
but we are at 9 a.m., I believe.
1 second, please. You're part of my 28, 30, 31, 39 matters on the 15th.
Is that?
Well, I'll be here for another one of those 39 matters.
Not at 9 a.m.
You're right, it's 8:30.
Pardon?
Are you in trial that day, Your Honor?
No, only 39 matters, I don't have trial as well.
Okay.
If court's indulgence, please.
Let me see, hold on 1 second, I'll be able to answer your question in part right, because you're here already on an 8:30 matter.
I will be, Your Honor.
You're intended to be.
Judge, we just as soon keep that date. That's
Okay.
set.
Be cognizant, I have my Rule 16s at 10:30, so realize that we will have to be more,
I was just thinking that, Your Honor. I imagine we can be a little more to the point.
hold on a
Very
second.
succinct.
25 minutes. 25 and 40.
We'll set a limit of 2 Latin phrases.
Just 2? No.
I'm not sure we're agreeing to that.
Okay. The inclusion of one is the exclusion of other, are we agreeing that one? Okay.
Res ipsa, that's what I expected the state to say. I don't know.
Okay, so you all want to keep, right,
Zio
we put you at 9 o'clock for probably the reason that we have some weighty matters at 8:30.
I'll be efficient in that one as well.
Okay, well, and then I've got motions and lemonade and a lot of other trial stuff for one of my trial stack coming up in November, so we'll see where we're at, okay? And then, yes, my mandatory Rule 16s come up at 10:30, so you can appreciate 8 of those. And it is what it is.
We'll talk fast.
Right, well, what I was doing, and does it make more sense to you guys on the afternoon, excuse me, with the council prefer, let me see what I'm doing. Those are all the morning. Would y'all prefer an afternoon on the 15th? Would that be more helpful for people that are?
I actually have a
less
federal court hearing, but I'll, at 1:30 that afternoon, Judge, so that's
not great for me, but if Mr. Sneed says it is, I'll see what I can do.
Your Honor, I believe that would work for the state, and
Here's what it is, as lovely as it is for you all to go, let's do this. Speak with your respective people, right? Today is still the 7th, let me know by the 9th, whether you want me to change it, because probably, there's somebody, there's always another case that wants the afternoons, right? If I have any time in the afternoon, so I give you till like noon on Wednesday, can you speak among yourselves and see, if not, we're gonna keep it at 9 o'clock for now, but if you're changing it, then let me know. If you want the afternoon at 1:30, then let me know by noon on this Wednesday. Does that meet the parties' needs? That way we can talk, whoever they need to talk with? Yes, 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 and yes?
yes, Your Honor.
Okay, so you know it's staying as is unless I get a specific request, okay? By Wednesday, because then I can make some others, I'll do it by other cases. I do appreciate it. If there's nothing else, I'm gonna wish you all a great rest of your day. Happy flights, whoever's taking flights, happy drives, whoever's taking drives. Have a great rest of your week. Take care.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah, I wanted to wait until after the hearing, right, to find out. Stipulation proposed order regarding state's motion to supplement the record on order shortening time. You also made a proposed briefing schedule, and then you requested that you not have a hearing until after December 3rd. Is that still the party's intention?
Yes.
Yes, Your Honor, I think the state's brief would be due shortly before the week of Thanksgiving, and we're hoping to avoid a hearing that week or even the Monday right after, so.
December 4th, then, is what I need to give you. December 4th works everyone, Wednesday?
Let me
Yes.
take a look, but I imagine that.
Well, it's gonna need to work, if not, I gotta put you on Monday because of trials.
One of those ones.
Oh,
Sorry.
The right way.
the short answer is,
Yeah, that works for our side, December 4th. Did you say a special setting at 10?
I'm likely starting a trial on that Monday, so I can pitch you in early morning on that December, but so we're gonna set you 8:30 on December 4th, councils for state, yes or no?
Yes, that works, Your Honor.
Okay, that's what we'll do, thank you so much.
Thank
Thank you, Your Honor.
you. Sorry.